Do what you want, sir. You have the power.
For the record, this matter is before the court on the plaintiff's motion to enter a default judgment of custody. This hearing is being conducted via Zoom. Present is attorney Cory Shimmick, representing the plaintiff, mother Alyssa Johnson. Ms. Johnson is not present. The court's informed that she was hospitalized this morning. However, the defendant, Timothy Westmoreland, is present. Mr. Westmoreland, you've not appeared numerous times. So can you please state your name on and your mailing address for the record, please?
Timothy Westmoreland, 48180.
Mr. Westmoreland, did you receive the proposed default judgment of custody?
Yes.
Okay. Why should the court not enter that today? Because you've repeatedly failed to appear. You didn't file an answer to the complaint. You've failed to appear at least 2 times in the past. Why should the court not enter this?
I have no idea.
All right. This gives a mother and sole legal and physical custody of their 7-year-old child. Parenting time. This order provides you have parenting time every other weekend during the school year and week on, week off during the summer. Do you currently have any contact with your son, Miles?
Yes.
Is that what you're doing? You're practicing every other weekend?
Yep.
Okay.
And last year was every weekend.
Okay. Again, so you don't know why the court should not enter the judgment. If in fact you're problem with, you can always file a motion to set aside the judgment. But you've failed to appear numerous times. It's creating unnecessary expense for Ms. Johnson, and it's taken a lot of this court's time to get to this point. Mr. Westmoreland, are you opposed to the court entering this judgment? You've received a copy, you reviewed it. You've had a chance to talk with Attorney Shimmick this morning. Are you opposed to the court entering this judgment?
Yes.
Okay, and what are you opposed to? What are you opposed to?
I just want 50.
So you're okay with the custody order? You just want 50-50 parenting time, is that correct?
I want 50-50 custody. And like everything else is fine.
Okay, so you're fine with the parenting time?
I'm fine with the parenting time and everything else, but the custody, I want 50-50.
Well, Mr. Shimmick, this court does not get hung up with this title of physical custody. As far as this court's concerned, I mean, if Mr. Westmoreland has been actively involved in the life of this child, I have to be convinced why the court should not order joint legal, so the parties can share equally any major decision concerning the welfare of the child, like elective surgery, education. And it's just really about a joint legal and parenting time. So it sounds like if in fact Miss Johnson would agree to joint legal, forget the word physical, Mr. Westmoreland's agreeable with everything else in his judgment.
Your Honor, what my client has communicated to me throughout this case is that the reason why she wants sole legal custody of the minor child is because Mr. Westmoreland has not taken an interest at all in any of those decisions in the minor child's life since he's been born, including his schooling, any type of medical decisions, anything like that. It's always been on her shoulders, and he has never offered to help or been interested in or wanting to participate in any of that. And it's been totally on her to do all of that. And she would like it to continue to be that way because she's the one who has been responsible for doing that and keeping up on it all in the past since the minor child has been born.
All right. Mr. Westmoreland, have you taken your son ever to the doctor, the dentist?
No, I have not. She won't let
talk to his teacher.
She won't let me. She never told me anything.
Oh, hold on. What's she doing? Is she preventing you physically from talking with the teacher or the doctor?
She won't inform me of any parenting teacher conferences. She never informed me of any doctor.
Hold on, Mr. Westmoreland. She doesn't need to. You have a child in school. Do you know where the child's in school?
Yeah, I know the child's in school.
You contact the school. Make sure that you're listed as contact information. That's something you can do. You don't need mom's permission to do that. You should list as emergency contact. In the event the child is ill or gets injured at school and they can't reach mom, they should be able to reach you. Well, and then when you're hold on, Mr. Westmoreland, when you're on that list, and you'll get notices of all the parent teacher conferences and report cards. You need to contact the school and make sure you're listed as a parent. You'll get all that information. You don't need to get that from Miss Johnson.
Yeah, but that doesn't help me with like doctors and stuff. I get what you're saying, but also if they don't know that I'm the father, then they ain't going to give me just the information too. You got
and Your Honor, Mr. Westmoreland could have reached out to myself if he really wanted to have access to any of this. He's had my information for a long time, and this is actually the first contact that I've had with him in this case is today. And I haven't heard anything from him regarding wanting access or my client attempting to prevent him to have access to any of that information.
Mr. Westmoreland, are you going to hire an attorney?
I don't have enough money to hire an attorney.
All right. Well, you've acknowledged not having played an active role in your son's life. You've not participated. This is the first time you've appeared. You've not reached out. You've created unnecessary expense for Ms. Johnson. At this point in time, the court's going to enter the proposed default judgment of custody and parenting time. If you have an issue about that, you can file a motion with the court to modify that. But you have a right to know where the child's doctors are. If you're going to hire an attorney, I'll give you a continuance, Mr. Westmoreland, one continuance. But I mean, we're not going to, if I adjourn this matter,
Sure.
Odds are you will not appear.
Do what you want.
Westmoreland.
You have the power. Do what you want, sir.
Well, again,
you have
convince the court that you're interested in that you're going to appear in these court cases. You've shown the court, and I'm a disinterested party. You've shown the court that you're not interested in the welfare because you've not appeared in any of these court hearings. There's been at least 3.
do what you want, sir. You have the power.
Well, I'm trying to get some input from you as a father, Mr. Westmoreland.
I'm in the kid's life. I've been in the kid's life.
Why haven't you appeared in court?
I haven't received any other notice about a court date. I showed up to the referee like a couple weeks ago.
Hold on. Mr. Westmoreland, you say you've never received any notices?
I didn't receive any other notification about anything else. I received
Hold on.
things
Let me
after.
go through the history of this case.
But
There
I
was
didn't.
complaint for custody filed by Ms. Johnson back in March 12th of 2024.
Yep. Papers after it was after.
Hold on. You were personally served with a copy of all those pleadings on March 13th,
Oh, no court
2024,
Out
12:55 p.m.
the
on
referee.
Superior Street, Suite 123, Taylor, Michigan. You deny having received a copy of the complaint for custody?
Do what you want, sir. You got the power. I
I'm
done.
just asking you, Mr. Westmoreland.
Just do what you want. You got the power. If you want to give her sole custody and let her.
Hold on. You
He
said
did
you
not-
didn't receive any of this, Mr.
No.
Westmoreland, and if you did not receive these pleadings, then the court's going to adjourn this matter.
I
I'm
did-
asking you, did you?
When you guys already made the judgment, I did not receive the date of the court. I asked her for the court date. She did not give it to me. She called me the day of court and said, "Why are you not here?" That's the type
Okay.
of stuff.
Your Honor,
Let's take one step at a time. You were served with a copy of the complaint for custody on March 13th. And that summons said you got 21 days in which to file a written answer. You did not file a written answer, but do you acknowledge receiving a copy of the complaint for custody, Mr. Westmoreland?
No. If it had a court date, no. If it did not have a court date, then I probably did. And I don't know.
Okay, didn't have a court date, but it was a legal notice that said you have 21 days in which to file a written answer. You didn't do that. So then what happened, let me go through the file, is that Mr. Shimmick filed a motion to establish the interim child support. And that was scheduled on May 28th, 2024 at 3 p.m. And that was mailed to you at 5964 Banner Street, Taylor, Michigan, 48180, along with the Zoom instructions. And you failed to appear on May 28th, 2024. We waited the 15 minutes for you.
Bringing me through the dirt, man. Just if you're going to do it, do it.
And you were mailed a notice of that on April 8th for a hearing on May 28th. So that was a hearing you had like 6 weeks advance notice, Mr. Westmoreland. Mr. Shimmick, were any of these mailings to Mr. Westmoreland being returned as being undeliverable?
no, Your Honor.
Okay, so that was May 28th. And then the next thing in this matter, May 20th, the court entered an order for child support. Have you been paying any child support, Mr. Westmoreland?
No, I filed for Social Security. So I don't have nothing at the moment.
Well, does the child receive Social Security?
No, I just filed for Social Security.
Okay. Okay, so the answer to the court's question, you've not been paying child support, correct?
Yeah, I already talked to the referee a couple weeks ago about that.
Okay, and the court file reflects that on May 29th, the copy of his order of child support, or you pay child support of $377 a month was mailed to you on May 29th, 2024. Did you receive that order for child support?
Mm-hmm.
I'm sorry, is that yes?
Mm-hmm.
Is that yes or no?
Yep.
Okay. All right, so you received that. And then thereafter, Mr. Shimmick filed a motion to enter a default judgment of custody. That was set for hearing on September 18th, 2024. A copy that was mailed to you back in April. Copy of the motion to enter default judgment of custody. Notice of hearing, proof of service. Mr. Shimmick thereafter adjourned the matter. The clerk entered a default against you on August 16th, 2024 for your failure to answer the complaint. It appears that you were mailed the notice to appear before the front of the court referee McKee on September 25. Did you appear before the referee on September 25 for your failure to pay child support?
Yep.
Okay. Again, that was for the front of the court referee. So this matter was adjourned to today's date at 1:30. This is the first time you've responded, Mr. Westmoreland. So what do you want to do, Mr. Westmoreland?
I want 50-50.
Okay. Are you going to hire an attorney?
I ain't got no money to hire an attorney.
All right. All right, Ms. Brower, the court's going to enter an order today referring the issue of custody and parenting time to the front of the court for formal investigation recommendation, please. Mr. Westmoreland, one more opportunity. Mr. Westmoreland, you need to file a motion to set aside the default. You need to take action. Go online. You need to figure out what to do. You just can't sit back on the sidelines. So the court's going to enter an order today. I'm going to refer the issue of custody and parenting time to the front of the court for formal investigation recommendation. And you got to be proactive. If you're not paying child support, you need to file a motion to reduce your child support. Don't sit on your hands, because that support is piling up at $733 a month, and you can't retroactively modify that. So if you don't have the income, you're unemployed, you're injured, you're incapable of employment, you need to file a motion to reduce or modify your child support. You can get those forms online. Talk to the front of the court caseworker. Got to be proactive, Mr. Westmoreland. Otherwise, you're going to start, but you're digging yourself a hole, $733 each month until you file your motion.
Your Honor,
So
may I ask?
Front of the court's going to mail out a questionnaire to both Ms. Johnson and Mr. Westmoreland, and both parties need to answer that. Then, Ms. Brown, will there typically be a phone interview then?
Yes, Your Honor.
We have a 7-year-old child. And Mr. Shimmick, anything further?
Your Honor, I would ask Mr. Westmoreland if he could give me a phone number that I could contact him at so that I can reach him.
Mr. Westmoreland?
Yeah, 1-2. It's my house number.
And Your Honor, when I speak to my client and if the parties end up having an agreement in this matter and we have a signed consent judgment, would we be able to simply submit that, or would you want us to appear to take any type of proofs?
No, I don't think we need to take any further proofs. At first, I was confused. I thought maybe it was a mention of a default judgment divorce, but it's not. So I don't think we need any further proofs. I think the parties' approval of a consent order would indicate their consent. They believe it's in the best interest of their child, that the parties, that the order is in the child's best interest. So even if we'll take one step at a time.
Okay. All right. That is my intention, Your Honor, to hopefully have a consent judgment signed. And if we do, I will submit it to the court and hopefully we can get this matter resolved.
So Mr. Westmoreland, you simply want joint legal custody. Is that correct? And you're okay with the parenting time?
I mean, for right now, yeah, because that's just fine for me right now. I just want 50.
Parenting time can be modified. And with joint legal, Mr. Shimmick, if you're a client, if they're the child's going to the emergency room, all you gotta do is notify him. And again, if he wants to participate, show up, or ask questions, then so be it. If he doesn't, then so be it.
Understand, Your Honor.
Mr. Westmoreland, he can sign up, get all the contact information from school, but yeah, mom should let him know who the doctor is, who the dentist is, and just keep him generally informed. If he chooses not to participate, need to look on decisions, so be it. So in event, Mr. Shimmick, if in fact there's not a consent order, if you could renotice the matter for hearing, the default judgment, if Mr. Westmoreland has not filed an answer, take another action, you can renotice that for entry after the front of the court issues its formal report and recommendation regarding custody and parenting time.
Okay.
Or do you want to hold off on that? Do you want to hold off on going through that process to see whether your client, is that something you can recommend to your client? I hate to waste the front of the court's time on that. Parenting time, I guess, is not an issue.
I think we can hold off on that, Your Honor. I am fairly confident that we will have a consent judgment to present to the court in this matter.
All right, we'll strike that then, Ms. Brown. We will not refer it at this point in time. So let's just put it over for a couple weeks. Mr. Shimmick, you can talk with your client. Hopefully he gets out of the hospital. You can communicate with Mr. Westmoreland. Mr. Westmoreland, if you get a phone call, Mr. Shimmick, return his phone call. We just want you to, if you're going to participate, just don't play games, please.
I'm not. I mean, I don't even know if you guys had my house phone, but I got an answering machine. Leave a message if I don't get it.
You have a home address and you're not checking your mail, sir. You need to respond.
I live here, so I don't know. Anybody could grab it. I'm not the only one that lives here, sir.
Okay, so let's give it. We're going to set this for a continued motion hearing. Are you available on October 24th at 1:15, Mr. Shimmick?
Yes, Your Honor.
Okay, that's 2 weeks. Will that be enough time to communicate with Ms. Johnson and get Mr. Westmoreland into your office to approve something, or he can perhaps even sign electronically?
Yeah, yes, it should be, Your Honor. And Mr. Westmoreland, do you have an email address also that you could give me?
Yeah, at AOL.
Okay, great. Thank you.
Right, this matter is adjourned to October 24th at 1:15. The court will mail out notice to Mr. Shimmick and to Mr. Westmoreland. So Mr. Westmoreland, make a note right now, if you're not getting your mail, October 24th, 1:15 Zoom.
Okay,
You must appear.
I will. I promise.
All right, thank you, Ms. Brower and Mr. Shimmick. That will conclude this matter. You can zoom out.
Thank you, Your Honor. Have a great day.